So welcome to our Lessons from Litigators Webinar Series. Today we're going to be talking about hiring from the competition. And we have with us today Jim Peterson and Neil Marchand, who will be doing a panel type discussion. And I'm Laci Reséndiz and I'll be moderating. So let's start with Jim. Can you introduce yourself and also talk about your familiarity with the topics we're talking about today?
Sure. So I joined Miller Johnson 32 years ago, right out of law school, which was shortly after the Michigan legislature passed a statute that actually allowed for the enforcement of covenants not to compete or non-competition agreements. And so really from the beginning of my career, I've been involved in issues involving the enforceability of non-competition agreements, hiring from your competitors, or preventing hiring by your competitors.
All right, Neil, same question.
I joined Miller Johnson in 2010 after clerking on the Western District of Michigan for a phenomenal judge. And since I started my career, I've been working with Jim on non-compete cases. So going on 11 years now.
And how about you, Laci? Why don't you tell the participants about yourself as well?
Yeah, so I worked for the same phenomenal judge. And then I came over to Miller Johnson in January of 2020, so not long before the shutdown. But I've had the opportunity to work on some of these cases with Jim and Neil, and so it's been a great experience getting started. So this is just obviously the disclaimers that all of the lawyerly folks put in. So we can move on to the substance. So today's topics, we're going to be talking about agreements that impact hiring from competitors, how to approach hiring an employee from a competitor, addressing confidential information issues for information that may be in a new employee's or prospective employee's possession, and steps to take after the employee is hired to protect yourself in the event that litigation or a dispute arises. And so let's just talk about the basics. And so I'll start with you, Neil. Mm-hmm. Tell us, what is a trade secret?
So a trade secret is any type of information or business practice that derives economic value for the company by virtue of not being publicly known, and that company takes reasonable efforts to ensure that it's confidential and doesn't become publicly known.
Okay. And then is there any difference, Jim, between a trade secret and just confidential information?
I think there is. So trade secrets are defined by statute in Michigan and also by the Uniform Trade Secrets Act, which most states have incorporated. There's also a federal Defend Trade Secrets Act, which has a similar definition. And I would say it is more restrictive. That is, it includes less information than what employers can include in a confidentiality agreement. So in other words, something may not be a trade secret, but an employer may be able to protect that information by way of a confidentiality agreement, simply by saying our customer's contact information, for example, is confidential information that belongs to the company. In that circumstance, usually courts will look at that and say, well, there's an agreement that this is confidential. That agreement is enforceable, even if customer contact information may be available in publicly available sources on the internet, for example, or trade journals or things like that, so that it would not technically be a trade secret under the law.
And so you touched on, the differences between trade secrets and confidential information. And I think you talked a little bit about how that relates to our topic today. But can you tell me, how do those issues relate specifically to hiring from the competition?
Right. So I think whenever a company contemplates hiring an employee who is at a competitor or recently resigned from a competitor, it's wise for the employer to ask itself and to ask the employee, do you have any agreements with your previous employer? And insist on seeing those agreements. And really, it's all of them. It's not just an employment agreement, or it's not just a non-competition agreement, because there could be some restrictive covenants or restrictions in a stock purchase agreement or a grant of an option to purchase stock. And so it's important to see all of those documents to really come to a conclusion that you have confidence in as to whether this employee can join you without risking violating an existing agreement.
And then I'll shoot it over to you, Neil. Can you talk about tortious interference and how that ties in here?
Yeah, so tortious interference is really directed at the third party. So not the employee that you're hiring, but the new employer. And the concept is that the new employer knew of that former employee's agreement and tried to take acts, intentional acts to interfere with the former employer's contracts and relationships with those customers to bring them over to the new employer.
Yeah, and what I would add in the context of tortious interference claims, at least in Michigan, those are extraordinarily difficult to prove and to succeed on in court. Not that those claims are not asserted on a regular basis, but Michigan law it's very deferential to the new employer who hires the employee, and really the purpose in making that hire has to be improper, or it has to be inappropriate in some way other than simply being against the terms of an agreement.
Yeah. So have you ever succeeded on a tortious interference claim?
In fact, I almost never assert tortious interference claims because I think they are so difficult to prove. And I mean, there are other, I think, tactical reasons why, if you're going to sue an employee on a non-compete, you don't sue the new employer. One of which is, of course, if you sue the new employer, you've now added their financial backing to the employee's ability to defend the lawsuit, and sometimes that can prolong or make the litigation more difficult.
Mm-hmm.
All right, so we've kind of kind of going through the basics, we've talked about some of these agreements, but I want to define them and narrow down a little bit more. So I know Jim has talked some about the non-competes. Do you want to give your perspective of what those are and what they can involve?
Right. So the non-competition, the scope is preventing an employee from competing in the same line of business within a geographic area for a specified period of time. And so it's really about doing the same type of work for the new employer as the existing employer.
Okay. And in Michigan, how enforceable is a non-compete?
Depends on the county that you're in.
Yeah, and it can even depend on the judge that you're in front of. I think when Michigan went to a business court system in the last 5 or so years, that one of the goals was to have a little bit more predictability for businesses about these kinds of agreements and how they were going to be enforced. And so the way it used to be 10 years ago or so, we had to tell clients, unfortunately, we can't really predict if a court is going to enforce this agreement unless we know where it's going to be litigated and even which judge it's going to be assigned to. I think that's improved with the adoption of the business courts. But independent of that, right? I mean, the primary benefit of any agreement, particularly non-competition agreements, non-solicitation agreements, et cetera, is voluntary compliance, right? I mean, I recommend that clients have them with their employees, just because most employees who sign an agreement like that will comply with it voluntarily. They won't test it. And for the ones that do decide to test it, right, I mean, you've got to have a solid agreement. But that's really the one side of the case. We're talking about the other side when we're trying to hire employees. It is important to find out what kinds of agreements that they have with their previous or their current employer.
Okay, and Jim, slide right in and tell us more about what a non-solicitation agreement is meant to do and what it does do.
Right. So a non-solicitation agreement usually protects against solicitation of customers of the employer, right? And so it's often used for sales employees or people in a business development function, and the non-solicitation provision will specifically say that the employee is prohibited from soliciting employers, customers or clients for a period of time, sometimes even within a geographical area. But most courts will say you don't even need a geographical area if you have a non-solicitation provision, because the employee typically knows who the customers or the clients are.
And then do you want to talk about a non-hiring agreement?
Sure. So the non-hiring is akin to the non-solicitation, but for your former coworkers. And so it's to prevent the raiding of an entire office, so that the one person who comes over is not then used to try and reach out and grab every other key person from within the former employer. And to stop, it's to preserve the business continuity of the employees the former employer has.
How common are these non-hiring agreements in comparison to a non-competition, non-solicitation?
I would say non-solicitation, non-competition are more common unless the former employer had counsel drafting the agreement.
Okay.
Yeah, I think they're fairly common in a comprehensive agreement, right? Interestingly, I'm just wrapping up a case based in Indiana. Indiana does not enforce the post-employment restriction on hiring coworkers. And so, you do have to also look at the agreements and which state law applies and what that particular state law might be.
All right. And then do you want to wrap us up on this side with non-disclosure agreements?
Sure. So non-disclosure agreements or confidentiality agreements are the most common, I think, even more common than non-competition agreements, in part because I think employees are used to signing them, and employers don't get as much resistance when they ask their employees to sign a confidentiality agreement. And in that, the employer simply identifies the kind of information that it views as confidential, gets the employee to agree to that, and has a commitment not to use or disclose that confidential information during the course of employment or after employment is terminated.
And those agreements can be joined with an attorney fee provision that if there's a violation, attorney's fees incurred to enforce the non-disclosure are damages in the case to prevent further disclosure.
Do you see that in any of the other agreements?
You can, yes. Usually the attorney fee provision is broad enough such that it's any provision, if there's any violation of this agreement overall, then the attorney fee provision kicks in. I'm going to kick sorry, John.
So I was just going to add one thing to that, and that is all of these kinds of agreements are typically enforced through requests for injunctive relief, right? Rather than money damages or in addition to money damages. But the typical practice for enforcement of these kinds of agreements is, often there's a cease and desist letter. If that doesn't get the desired result, then there can be litigation. And in the litigation, there's usually a request for expedited injunctive relief. And injunctive relief is really asking a court to issue an order that specifically enforces the agreement and prohibits the employee from either competing, soliciting, hiring, or disclosing information. And that's often the case because the damages that are associated with breach of these kinds of agreements are often viewed as not able to be compensated with money damages. And so there's what's viewed as irreparable injury, in which case injunctive relief is the appropriate remedy rather than money damages. Although some of these agreements have liquidated damages provisions or things like that, or you can prove damages. And so it's also not unheard of for these agreements to be enforced and for money damages to be awarded by a court if the case goes to its conclusion.
Well, Did you have anything to add on this point or?
It relates to, I believe, what's going to be the next slide of when you're asking the employees for copies of this agreement, how bold do you get? I find that an employee sometimes doesn't remember what they signed 4 or 5 years ago. Do you have them go and ask HR?
Right. So I think as the new employer, if you're being careful, right, it is someone from your competitor, you can be very bold with the employee and say, we really need to see anything that you signed with your previous employer. And if it's a current employer, right, you can ask them to get a copy of the agreement, but you have to recognize that that's going to raise a red flag when the employee asks his or her current employer, yeah, I want to see either my personnel file or I want to see any agreements I signed with you. That can put the employee in an awkward situation. And it's just kind of a balancing issue there because, if you really want to avoid the risk, it is important to get a copy of all those agreements so that you can assess the risk.
And those agreements are sometimes in unexpected places. It's not just the initial offer letter. I think, as you mentioned before, any acceptance of stock options or a bonus or different compensation or new compensation or a promotion during the employment can have a different agreement provision included.
Will you see any of this also in like an employee handbook or anything like that?
You can sometimes more so the confidentiality might be in an employee handbook. More comprehensive agreements are usually standalone.
Okay.
That's true. But I do think seeing the handbook is important because there was a period of time, right? And I'm sure some of our participants on this webinar will remember where the handbook really was all encompassing with the obligations of the employee. And it would have language in there that would say, this is not a contract, right? And so then there were issues with enforceability of those kinds of provisions under the Hurtubise case, right? But then, companies got wise. They asked their counsel, how do we address this? And so the handbooks would say, this is not a contract except for the provisions regarding confidentiality and non-competition, which are contractual. So anyway, it is important to really see as many of the documents as you can as the prospective new employer. And I think for the lawyers too, right? That we as lawyers advising companies in that situation want to see all of the agreements. It's very difficult to give advice as to what the level of risk is if there are agreements that we haven't seen or that exist, but we don't even know about.
And then, so we've talked a little bit about the agreements that you want to get, and then taking the time to determine if a prospective job is covered by that agreement.
Mm-hmm.
How do you handle taking the next step? How do you address handling the information about the competitor?
So first, you need to make clear to the prospective employee that you don't want it. The best way to do that is in writing, and mean it. It's not just you don't want it, nudge, nudge, wink, wink. Have them truly start with a clean slate. Mm-hmm. The issue that frequently comes up is that during the course of employment, maybe someone's working in the evening, they need a print from home, so they email it to their personal email address to be able to print something from home. So what happens when they have information on their own personal devices? The individual needs to really examine their own devices and thoroughly look to see if they have anything of their former employers. And then you get into the best way of handling that. You don't want a copy of it, but you do want to know what exists if they have information there so that you can have them delete it or as part of an offer letter or their resignation letter offer to have the employee offer to their soon-to-be former employer that a forensic examination to have everything examined and all of the former employer's information removed from any personal device in their possession.
Okay. And I think that's helpful. Can we take one step back. And so when we're in the kind of recruiting phase, so you want to see if there are any agreements, see if the hiring of that employee would violate any agreements or what restrictions we have. What else can you tell a client or a new employer to do in the recruiting and hiring process?
So I think, getting back to that issue of looking at the agreements that exist, it could be that the agreement prohibits certain activities so that you could not hire this employee in a particular job function or for a particular segment of your business, but you might be able to hire that employee for a different segment of your business. Or you might even conclude in connection with conversations with your lawyer that there are provisions in the agreement that are overly broad and unlikely to be enforced by a court. And in that, in that situation, you might say, well, we recognize there's some risk that there will be an allegation that this breaches the agreement, but there is solid Michigan authority or other state authority that says this kind of provision is not enforceable for an employee in this circumstance. And so, I do think the agreement is a good place to start, but then having some flexibility in what you may do for this employee to increase your chances of successfully fending off a claim or even a dispute to begin with, I think is important.
Okay.
But transparency with the employee you're bringing on board as to what you hope to have her do for you, I think is important. And then I also think it's important because most employees I've dealt with over my career don't either realize how much information they may have in their possession based on their work activities, or think that, oh, I should be able to keep this because it will help me in my future employment. And I've seen other people keep similar information. And so it's I would say it's not the usual case that employees leave, as you say, with a clean slate. Usually they have some information in their possession, and you need to make sure to direct them not to use that or disclose that on your behalf. And even to push back and say, we need to double check to make sure you don't have any of this information.
So let's talk about, you find an employee that you want to hire.
Mhm.
They currently work for a competitor or have recently worked for a competitor. What would you do in crafting the offer letter to that employee?
I would include a couple different statements and provisions. One saying a representation from the prospective hire that they're not violating any of their prior agreements. While you may have some, you may not know the universe. And so the employee, having that employee represent that they're not violating anything helps insulate the new employer. I would also include a provision that that new employee is specifically directed not to use any of the information of their former employer. And if they do have an agreement, that they need to abide by it, and that this provision is this offer is contingent on them doing so.
And so what would a contingency like that look like? Would it be a termination of employment if they do violate something? What would that look like?
You can really frame things in different ways. I'll pitch this one to Jim, though. In my experience, termination is certainly the most protective form for the company hiring the employee, but sometimes they don't want to terminate.
Right. And so, you can have employment be contingent upon that representation and warranty. You could also have an indemnification provision that says the employee will indemnify the employer in the event there is any litigation arising out of a breach of that employee's prior agreement or prior employment agreements. Those are difficult at the inception of the relationship, right? You want to bring this person on board, and so you don't want to insert provisions that are going to thwart that that new relationship, or that are going to cause the employee to say, hey, wait a second, what am I taking on here? But if the employee really is confident that she doesn't have an agreement with any prior employer, then they may be willing to sign that kind of representation and warranty. The other thing I would say about that is it's not only the most recent employer that you have to ask about. It could be an employer before that, because it's not uncommon to see non-competition agreements with a restricted period of 2 years. And in the context of a sale of a business or something like that, a sale of an interest in a business, it can be 5 or more years. And so it's not just the most recent employer that you should ask about it. It really is any prior employer, within the last 10 years or so, where there may be some kind of restrictive covenant.
So what if you've gotten the agreements from the employee, the lawyers looked at them and said, there are, by the letter of the agreement, there might be a breach, but there's no way this will be enforceable under Michigan law. What could you put in an offer letter then that might deal with that, where they can't represent that there would be no breach?
Sure. Yeah.
But it's probably not enforceable.
Right. So what we've done in that context is have the employer represent and warrant that the employment that is being offered to him or her would not violate any enforceable obligation that employee has to a previous employer. And so, I mean, that's possible as well. And, taking a step back as well, right? I mean, so employers who are looking to add talent, right? They come at it with different perspectives. And some employers will say, you know what? We need someone so badly, or want someone so badly, we're willing to accept more risk in bringing this person on, that there will be a claim asserted against us for either this employee breaching an agreement, or for a trade secret claim, or things like that. And then on the other end of the spectrum, right, there are some clients who are very careful. They don't even want to risk a claim being asserted. And so they will say, if that person has any kind of restrictive covenant that would give rise to a claim, we're going to pass on that person for now. And so part of that is just having a conversation about risk tolerance, and what can be done to address the level of risk that the new employer is willing to take. I mean, I've had it where there are actually negotiations between the two companies about what the employee can or can't do.
So if we have a company, they really want or need this prospective employee, but the employee might be hesitant because of their past or current employment, what could that company do in terms of making the prospective employee feel more comfortable with making the move?
Yeah, so there's a couple different things, and a lot of this depends on the former employee's comfort level and the new employer's comfort level. Sometimes you can ghostwrite a resignation letter, or have formal negotiations, as Jim mentioned, between the new employer and former employer. If that's not something, you can offer a couple different things to that new employee. Offer to pay for their legal fees. That is something, and indemnify the new employee in the event that new employee is sued. The new employer can do that if they want talent that bad. They can also have, a lot of the issue in these cases is a breakdown in trust between the former employer and the former employee. And so having that transparency between the two of them up front can aid in the process of moving on. There may be frankly, a buyout of any and all obligations the former employee has to the former employer, and as part of their offer letter, you pay that former employee the money needed to buy out of any agreement with their former employer.
Yeah, often it is the employee who is still employed who is in the best situation to try to resolve any potential further dispute. I've seen the situation where employees are terminated without cause. And in that circumstance, some employers would say, yeah, we feel badly, we're letting you go at this point, but we're not going to enforce your non-competition agreement or non-solicitation agreement, or we're only going to enforce it as to these 5 clients that are really key to us. And so in that situation, often it is the employee who's best positioned to try to avoid a dispute in the future, because Neil's right. When an employee resigns, particularly when it's a surprise or without much notice and goes to a competitor, the most natural reaction for the existing employer is distrust and to assume that the worst is going to be happening. And so that's why I say transparency is important. If you're hiring this new employee and you don't believe the employee is going to be in a position to cause harm to the previous employer or to breach his or her agreement, I think that you can forestall a dispute if you put that in a resignation letter. And even I've drafted letters for the new employer to send to the competitor saying, we understand you might be concerned about this. We don't believe that there's going to be any breach of the agreement. Here is what we're going to have this employee be focusing on. We've instructed the employee not to use or disclose any of your information to us. We won't accept that information. If you want to talk about anything in this letter, please feel free to give us a call. And it's not uncommon, particularly in West Michigan, right, for the HR people or for the heads of companies to know each other and to be able to have a conversation about here's what our concerns are and here's what we don't want you to have this new person doing for you. Right.
We've talked about that sometimes this new employee might have information on their devices from a previous employee. You talked about the issue of you send something that you're working on at work, you send it to your personal email address to print. How common is it to see that an employee still retains something from their former employer?
It's incredibly common. And the employee often doesn't know that they have it because at the time they were sending it, it wasn't for any nefarious purpose. But when that trust breaks down, then everything becomes an intent to harm it from the former employer's perspective. And so the former employee very often has information in their possession. And that's why I like to offer, if in that communication from new employer to former employer, the forensic examination and what that is it's a computer expert who comes in, puts in search terms on all of their personal devices, finds information with those key search terms, and permanently deletes it. Mm-hmm. So it can't be used. I like that for 2 reasons. First, it eliminates information that might come out and bite you later. The second is that by offering it, if they don't take it, if the former employer doesn't take you up on that offer, then you have a good argument that they didn't try and mitigate their damages.
Or try to protect their information.
Yeah.
Right?
Exactly.
So I know that both you, Neil, and Laci, you've dealt with issues involving information that is on different devices, right? Electronically stored information, which is it's very common in the use of cell phones, right? Laptops, Chromebooks, whatever it is. And so what do you do in the context of an employee who actually pays for her own own cell phone bill, but has employment information on it. And what can you do in that context to preserve the information that's on there for the employee that might be personal, but to deal with the information that might be business related? And what if there's crossover between the two, right? Some of it might be personal information about friends, but often clients are friends. And so how do you deal with those situations?
Yeah, so what you can do is you can have the examiner and negotiate with the former employer to have an image of everything created from the devices, and then you review document by document. Okay, if these search terms came up, we feel this information should be deleted and this information should not. And this is counsel to counsel, usually attorney to attorney. And then you kind of negotiate what is and what isn't and come up with a list. Okay, this information is going to be permanently deleted off the device. Now, and then the forensic examiner can restore the individual's personal information back on their device. So they take it, wipe it, they have the universe set of all information on those devices, and you negotiate what is and is not confidential to the former employer, and then restore the information that is, pictures of the kids.
So that sounds like an expensive process.
It is. So the examination itself and the getting the image can be between $500 and $1,000. The going through line item by line item is much more expensive. Is a much more expensive process. And that's why I offer the former employer to pay those costs as a part of their efforts to protect their information and ensure that it's not being used.
So now we've had these kind of pre-hiring discussions and investigations. Then we've worked with the transition.
Mhm.
Now the new employee is hired. What do they do now, or what does the company do now to protect itself?
So, yeah, I think that depends on the posture of the previous employer in large part, right? I mean, it's if there is an immediate threat of litigation, a cease and desist letter, harsh words to the employee on the way out the door, things like that, I think then you have to be on your guard, right? And you even have to think about not just what do we do with this employee to minimize the risk, but you also have to think about, are there steps that we need to take, not with this employee, but with our lawyers to forestall litigation, or if there's going to be litigation, to position it so that we either are where we want to be, the venue we want to be in, or, and I'm sure we'll talk about that later, or at least kind of creating the evidence which will help us defend in the event that there's a dispute. But some of that is, right, I mean, often employees are friends with coworkers, and there is communication, there are texts, there are telephone calls, and I think, that's natural, but it's not advisable for employees to continue to stay in touch with other people at the company. There are people at the company who may just be fishing for information, trying to set traps for this employee by sending texts and asking questions, hoping to gain evidence against them. And so that's why we do recommend limiting contact with former coworkers. We know that's hard because coworkers are often texting or calling. And then, you can see the other things on the PowerPoint, returning property. I think it's critical that the employee leave without information. And as Neil has observed, that is not the most common situation, right? A lot of people have information that maybe they don't even know about, that's on their personal devices, or they've got information, they got an old laptop of the company, for example. Things like that. And then, the other things about some of the electronically stored information, Neil and Laci are far more well-versed in those than I am. When I started doing this, it was, you had to make sure that they didn't have company brochures and papers and hard copies of things, so.
Yeah. So let's talk a
The
little
Pony
bit.
Express days.
So let's talk a little bit about these electronic accounts
Yeah.
or social media accounts or any type of accounts. Why do you suggest to change passwords to these accounts?
And as technology grows, there's just more and more types of accounts, Dropbox, cloud storage, and it just gets, there's more and more layers to that onion. If you're anticipating, depending on how the employee left, and if you're talking with counsel, you may be anticipating that litigation comes. So you have a duty to preserve the evidence that's relevant to the case. So the passwords, changing the passwords simply stops a former employer from going on your old laptop, pulling up the bookmark where you saved your passwords and seeing everything, or creating a message ostensibly from you to a customer that you actually didn't send. And so it just protects and kind of locks down the information so that you have it, it's preserved, but it's not tampered with. And you control the access, because if the if the former employer wants it and wants to proceed with litigation, they can do that, and you'll likely have to turn over that evidence in litigation. But there's a process for that. It's not that the former employer gets a free pass to go fishing.
Have you seen that happen before, where a
Yes.
former employer actually goes into their previous employees' accounts?
Yes, and not only, they went in and they not only looked at all the messages that were sent prior to departure. The new employee was using it at their new employer, and so they were determining where the new employer was targeting the employee for business development, and then had their own people follow that. And so espionage might be a strong word, but it's certainly useful information.
That's interesting. And I think, Jim, you brought up an interesting idea when we were discussing this informally amongst ourselves about using a whole different email address for pre-hiring discussions or even post-hiring. But when you're looking to communicate with a prospective employee, what can you do to separate that from their former employment?
Right. So the first thing, the most important thing, is not to communicate with that employee by email at the employee's current employer, for example, right? And we've seen that many times, and to instruct the employee not to use the company email to communicate with you, because all of that information is accessible to the employer, and to be able to see exactly when the communications began, the nature of the communications, and that's problematic. Aside from not using that, we have seen some companies who actually have employees set up a new email address, and it might sound suspicious, but it really is to prevent the issue of auto population of, right? I mean, if I want to send an email to Neil Marchand, and I type in Marchand and I want it to be his Gmail address, maybe it auto populates to his address at the company. And so it really is just kind of a preventative measure to make sure that you're not making mistakes that are caused by the auto population.
So you could actually put a different name on, say, when you're talking about like a Gmail address.
Sure.
That would make it so it wouldn't auto-populate. What could be a type of a change that you can make so it doesn't auto-populate?
Well, so I haven't actually done this, but what I've seen is it could be an entirely different name, right? It could just be a pseudonym for him. I have a hard time thinking of pseudonyms just off the top of my head, but it could be
Yeah.
a nickname that you have for someone that they don't use. It could be something as boring as potential new hire, something like that, just so that that it's not going to create evidence that can be used against you later. So you guys are more creative about what names you could use.
Yeah, and you can also, depending on your IT team, you can also have your IT team set up to block an email being sent out to a specific email address that you don't want it to go to. Now, so that can help on your own internal end as another check to stop an email inadvertently going to the prospective hire's employer's account.
Right. And the other thing in that regard is, so employees have a duty to their employers not to engage in competitive activities while they're employed, right? And so they really shouldn't be using company time, company resources to communicate with you as the hiring entity about this new position.
Right.
And I've seen it before where employees, even though something is sent to a personal Gmail account, they're checking their Gmail account from the company server, and that often gets preserved as well. And so it's best to communicate using those different personal email addresses, and to also tell the employee, don't do this. Let's not have these conversations during working hours, right?
Right.
Or while you're at work. Now, with the COVID situation, right? The question is, what are working hours, right? Those kind of went out the window in the last 15, 16 months.
Right.
And I think when we were talking, you brought up another benefit to having this full separate email account for discussions with a potential hire. What would that benefit be for you?
So to me, one of the most expensive parts of litigation is the discovery process. That's the fact-finding process where you're going to gather all the information that's relevant to that case. By having a designated email account, a new one that was used, you cut down on the amount of time and spent searching for relevant communications. And instead of going line by line between the email to my wife, the email to my friend, oh, this one's relevant. It's, hey, I only use this email account for the express purpose of communicating with my new employer. So this is everything that's going to be that there is. And it makes it really easy to preserve the evidence and take it and more cost effective in that regard. One point that Jim touched on, with the duty to the current employer, the prospective employee can't park a job. They can't say, hey, you know what? I know you really want to go forward right now. I'll contact you in 6 months. And then contact them after they go to the new employer. If the job's coming in at the current employer, it needs to come in at the current employer and not be pushed off.
Right. Yeah, it's even best for employees while they're still at their previous employer to refrain from any conversations with clients about the fact that they're going to be leaving, where they're going to be going, what they're going to be doing, any of that stuff, just because of the duties that they owe as long as they're there. And again, you're going to have mistrust and you're going to have miscommunications as well. And so some of those customers might interpret a totally innocuous statement about, I intend to resign my employment next week as being a solicitation of their business.
Right.
All right.
Sorry. On that point, we've had it where if a job is almost entirely complete, I've at least advised the new employee, if they say, you know what, I did 95% of this work at my former employer, but now they want to move forward, what should I do? Depending on their comfort level, sometimes send that job to their former employer just to ensure that there's evidence of compliance and to avoid the appearance of poaching the job.
Good point. So the next thing to talk about, we know that sometimes litigation is a reality. We're talking about all of the steps in hiring to try to avoid litigation, but when it looks imminent, how do we then de-escalate it? Jim, you want to start?
Sure. So cease and desist letters are sent on a regular basis, right? And they have threats of legal action in them. You know, and the question is, how do you respond to it? Do you respond in writing? Who responds? Is it the, you know, is it the HR, the VP of HR? Is it the president of the company? Is it the lawyer, right? And some of that depends on from where the cease and desist letter was sent. If it was sent by counsel, I almost always advise that counsel should respond to it. But I usually advise that the response should not be in writing, but should be by telephone call. And that's because, right, if I see a cease and desist letter from a lawyer in Michigan that I know, it's more likely that I can find out what posture the company is going to take in a telephone call than by simply responding with a letter. I can find out, engage, okay, are they just sending a shot across the bow here to say, be on your best behavior? Or is the next step litigation? Or are they looking for a conversation about how to address their concerns? Those things are so much easier to determine in a telephone call than just by trading letters or emails among lawyers. And so, you know, I almost always recommend a telephone call as a response to say, okay, we received your letter. We don't think there's a violation. Here's why we don't think there's a violation, and to start the dialogue in that regard.
And Neil, do you want to take the next point and tell us what are declaratory actions? When would you see them from the current employer, the new employer, the former employer, and what is the strategy there?
So a declaratory action is basically seeking the court's guidance on whether the provision of a non-compete agreement or non-solicitation is enforceable and to what extent. And so you're seeking that order and guidance from the court. From the new employer's perspective, you may want to file it if you want to pick where the litigation is going to occur, if you're confident the litigation is going to go forward. But know that once you cross that line and file, you're having litigation because the immediate response is you breached it and here's why. And so you have to be careful on whether you choose to go that path, because you have to know that from the new employer's perspective, you are in fact going to have litigation if you file it. There may be an advantage to doing so, but you have to weigh the pros and cons.
Yeah.
Right. I recommend that really as a last resort. If we're almost sure that there is going to be a lawsuit, I would rather file first a declaratory judgment action seeking either a declaration that the employment of this person is not a violation of the agreement, or that certain provisions in the agreement are unenforceable. And part of that is because of often these cases involve immediate injunctive relief, right? And so if you sit back and wait for a lawsuit to be filed, it can be filed without your notice, right? They can go in and request what's called a temporary restraining order, and even do so on an ex parte basis, that is without giving you notice or an opportunity to be heard. And at the timing of their choosing, in the place of their choosing. And as a litigator, I would rather have the timing be of my choosing, the place of my choosing, and really to be able to tell our side of the story first. Right. And so you can even get expedited relief on declaratory judgment actions if you think that's to your advantage. And often it is in this context, because for business planning purposes, you want to know what this employee is going to be able to do for you and what the appropriate restrictions are.
Right.
All right, so let's talk about solicitation issues. We've talked primarily about competition and confidentiality. Let's talk a little bit more about solicitation. What does that look like? What constitutes a solicitation? And how do we deal with these non-solicitation agreements?
So this is where having the agreement is critical, because sometimes the agreement will say solicit, you should not solicit. And sometimes it goes a lot farther to include, you will not accept business from former customers within the last 6 months of your employment. And so the two different provisions have a very different impact, but that really goes to the scope of the non-solicitation agreement. But really what you're looking at here is reaching out to the customer of your former employer and saying, hey, I'm at a new employer, you should do business with me here because we have a much better deal. Mm-hmm. Now, different jurisdictions have different views on what constitutes a solicitation and whether the new employer can effectively advertise the new employee's hire, in that they should be doing business with that new employee.
And for the most, risk averse among us, what would you avoid as a solicitation based on some of these broader definitions of solicitation?
So my view is that anything that is targeted to customers or clients looks a lot more like a solicitation than a public announcement, right? So something in the Grand Rapids Business Journal or on LinkedIn, which says, we're pleased to announce that Laci Reséndiz has joined the firm. I don't think that is a solicitation. That's a simple announcement. If I follow that up with targeted emails to those clients, right, then it looks like a solicitation, even if I'm not explicitly asking for business there or saying Laci's available to take on matters for you, things like that. Anything that is either targeted or looks like an invitation to do business, if you want to avoid or minimize risk, I should say, on a non-solicitation provision, I would avoid those things. But the general announcements, I think the vast majority of courts have said those are not solicitations.
Right. The employee can update their LinkedIn to show where they're at now.
Yes.
Okay. So let's talk about just kind of the catch-all. So we've had a pretty fulsome discussion and just being cognizant of the time, we're hitting 9 a.m. So let's just do a couple last points. I think you can probably speak to this as much as anybody about the charged motions and trade secrets cases. Yeah. How does that play into litigation or avoidance of litigation?
So I find that the emotions and the distrust often drive the former employer to sue more often, just because there's a fear. And so that's where going with transparency, having the communication can help assuage that fear and give them comfort and can stave off a potential case. They may say, okay, I don't believe you, we're going to watch. But instead of immediately going and suing, they sit and watch. And if the former employee, your new employee, is complying, you may not end up having that case.
And then do you want to speak to what do we do if this employer or employee is coming from another state?
Right. So it is important to see not only from what state the employee is coming, but what state law is going to govern the obligations. It could be that in fact, I'm just wrapping up a case where the employees were hired for Michigan, from Michigan, but their previous employer was based in a different state. And so that state, their agreement said that state's law controls. for purposes of enforceability or application of the agreements. And so you have to look at that, even if it's someone you're hiring from Michigan for Michigan, what law governs that employee's obligations? Because, you know, companies that are based elsewhere can say their law governs the conduct rather than Michigan law, even if the employee is based in Michigan. And most times courts will enforce those kinds of provisions. So, but it is important, I think, to know what law is going to apply to the obligations, and also know what forum is any dispute likely to arise in, because that may impact whether you decide to bring a declaratory judgment action or how you approach the hire overall.
Right, like California, if you're dealing with California, it may go to the point of the new employer retains counsel to advise the prospective employee on any agreement so that you can fit within some of the exceptions to the statute and have an enforceable agreement.
Yeah, California is definitely a wild card with regard to these issues. So it is important to recognize that.
Yeah.
Okay. And because we talked a little bit more about email earlier, and in the interest of time, I think we're going to wrap up. But thank you, Jim. Thank you, Neil. And obviously, thank you to our IT folks who really run the show in making this work. So thank you for coming today, and have a great day.
Yeah, thank you. And thank you, Lacey.
Thank you, Lacey. Yes.